instance of an accused while he is already in judicial custody in connection with his involvement in a different case. Our final conclusion is as under. An accused is entitled to seek anticipatory bail in connection with an offense, so long as he is not arrested in relation to that offense. Once he is arrested, the only remedy available to him is to apply for regular bail, either under Section 437 or Section 439 of the CRPC, as the case may be. This is evident from Para 29 of Gurbakh Singh CBR. 2. There is no express or implied restriction in the CRPC in any other statute or in any other statute that prohibits the Court of Session or the High Court from entertaining and deciding an anticipatory bail application in relation to an offense, while the applicant is in custody in relation to a different offense. No restriction can be read into Section 438 of the CRPC to preclude an accused from applying for anticipatory bail in relation to an offense while he is in custody in a different offense, as that would be against the purport of the provision and the intent of the legislature. The only restriction on the power of the court to grant anticipatory bail under Section 438 of the CRPC is the one prescribed under subsection 4 of Section 438 of the CRPC and in other statutes like the Atrocity Act, etc. 3. While a person already in custody in connection with a particular offense apprehends arrest in a different offense, then the subsequent offense is a separate offense for all practical purposes. This would necessarily imply that all rights conferred by the statute on the accused as well as the investigating agency in relation to the subsequent offense are independently protected. 4. The investigating agency, if it deems necessary for the purpose of interrogation/investigation in an offense, can seek remand of the accused while he is in custody in connection with a previous offense, so long as no order granting anticipatory bail has been passed in relation to the subsequent offense. However, if an order granting anticipatory bail in relation to the subsequent offense is obtained by the accused, it shall no longer be open to the investigating agency to seek remand of the accused in relation to the subsequent offense. Similarly, if an order of police remand is passed before the accused is able to obtain anticipatory bail, it would thereafter not be open to the accused to seek anticipatory bail, and the only option available to him would be to seek regular bail. 5. We are at one with Mr. Dave that the right of an accused to protect his personal liberty within the contours of Article 21 of the Constitution of India with the aid of the provision of anticipatory bail as enshrined under Section 438 of the CRPC cannot be defeated or thwarted without a valid procedure established by law. He is right in his submission that such procedure should also pass the test of fairness, reasonableness, and manifest non-arbitrariness on the anvil of Article 14 of the Constitution of India. 6. Under Section 438 of the CRPC, the precondition for a person to apply for pre-arrest bail is a reason to believe that he may be arrested on an accusation of having committed a non-bailable offense. Therefore, the only precondition for exercising the said right is the apprehension of the accused that he is likely to be arrested. In view of the discussion in the preceding paragraphs, custody in one case does not have the effect of taking away the apprehension of arrest in a different case. 7. If the interpretation as sought to be put forward by Mr. Luthra is to be accepted, the same would not only defeat the right of a person to apply for pre-arrest bail under Section 438 of the CRPC, but may also lead to absurd situations in its practical application. So we have also explained why Narinderjit Singh Sani should not come in the way of applying. So we are dismissing the appeal with a clarification that now the bail will be heard on its own merits. You are appearing? We have allowed the petition. We appoint Shri Justice Mohit S. Shah, former Chief Justice of the High Court of Judicature at Bombay, to act as the sole arbitrator. The fees of the arbitrator, including other modalities, shall be fixed in consultation with the parties. It is made clear that all the rights and contentions of the parties are left open for adjudication by the learned arbitrator. Fine.
In 1502, I'm not in the matter, I have nothing to do with the merits. But when your lordships were hearing the constitution bench on this issue, Lord, my lords were pleased to require the original file of the government to be placed for my lord's consideration, which was placed. Lord, if that can be returned.
Can be fair.
Yes.
When the 7-judge matter was going.
Yes, at that time, my lords.
Yes, of course, that. Make sure that is returned to the Solicitor General.
Lords, if I may, if I can mention, my lords, there's a matter for which we've sent an email. We have also gone between 10 and 10:30, as the lordships have mentioned. It's listed tomorrow before the single judge division bench of the Madras High Court. Despite judgments of the Madras High Court which say quashing petitions must be heard by single judges, about 30 matters have been heard and disposed of, dismissing the quashings. We are a little
Yes,
concerned.
okay. All other mentioning applications, the moment we rise, I'll pass orders so that we'll have orders by the.
Except for these are matters before your lordships, after notice matters, lords, concerning the university which your lordships have been hearing in part, lords. Sorry, my lords. My lords, it was last listed before your lordships bench, my lords, on 13th of February, my lords. Since then, it has not come up. It's showing on 13th of October. It may not be deleted, because there's some.
All non-deletion requests also just give us in an email and make sure that I pass
It
one.
previously pending this matter for listing. So after notice matter, bro, 1100 crore award in my favor, upsetting 37,
Email.
and not a rupee brought in security.
Thank
And we had previously emailed, but it keeps appearing and disappearing from the list, bro. It be not fixed.
All
So replied. Last it was listed in March, to be listed in April. So replied.
My lords, may I mention two writ petitions, which are already,
Say it on the email. It's a fresh matter.
oh no, my lords, only for non-deletion, my lords. The date
Yeah,
is
just
showed
say
as last 3 days, it was deleted, my lords.
Just send an email. I say NTD.
Email
I've
is-
even got a code. NTD, not to be deleted, and I initial it.
Yes, my lords.
Only thing is the reason I insist on emails is because then it's tabulated. So then it's easier for them
Yesterday we
to
have sent an email.
process it.
We have sent an
I have a tabulation by the end of the day, so that I would just say NTD and initial it.
My lords, this is a writ petition filed on 9/7, my lords. Defects were cleared on 18/7. Since 50 days, it is not being tested, my lords.
1 second. Right, I'll tell him. Just send an email. I'll circulate.
My lords, may I mention a matter which is listed today before my lords? My lords, actually,
Wait for the matter to be
Lordship.
called out. Wait for the matter to be called out, yes.
like,
My lords, we have filed, my lords, the status report, which you have circulated yesterday. And then, my lords, We've also filed the report of the State Health Department. They they've not gone back to work, the doctors, 23 people have died in the process.
Now, what about the CBI? Has the CBI?
Lord,
prepared a
my
status
report
report?
is ready, my lord.
We saw your status reports, which were,
We filed a separate application, which
Lord,
I think has.
I don't think I have the copy. I'm not complaining. I'm just requesting him, my lord, to give it to me right now. Maybe they have served, it has not reached me, or they have not served, whatever.
It's not served. It's
Hmm?
not served.
Not served, my lord, they have not served on me.
Yes. Put it in a sealed envelope and therefore we.
Okay. These for the parents. Say one thing, my lord, what is filed by Mr. Sibal is not served upon me. That's what he says.
It is not filed. It's not filed. It's only given to the
But if
court.
they want to say something, why hide something from the CBI?
well,
You've
let's
already
see
done
what
many
the-
things.
I mean, I think let's not get lost in.
Yes,
Yes,
Let's see what let's see the, first and foremost, let us find out what the status of the investigation is.
Yes. Not even with them.
the residence of the, Mr. Solicitor, what is the distance between the residence of the principal of the Ajikor Medical College and the medical college?
15 to 20 minutes it takes, maximum.
More than 6.
I think